Hello, everyone. I'm Will Trackman, the General Counsel of Mountain States Legal Foundation. We're excited to bring you a series of webinars over the next 2 weeks that will look at some of the cases decided by the U.S. Supreme Court before its October 2021 term closes next week, likely. We are very excited to also have the director of the Center to Keep and Bear Arms, Cody Wisniewski, with us today to help us analyze the decision in New York State Pistol and Rifle Association versus Bruen. We plan on doing a series of these webinars, so stay tuned for others. We will have a few more decisions before the end of the Supreme Court term. We aim to go about 20 to 30 minutes with these and talk through the background and the facts of each case, the holding of each case, and then the implications. We'll touch on some of the implications for the cases and where we expect the law to go from here. And we are excited to begin this series with the Bruen case. With that, I want to pose my first question to our Center Director, Cody, which is, what happened this morning? Tell me about the basics involving the facts and the holding in Bruen.
Yeah, absolutely. And thank you, everybody, for joining us. It was quite the morning. What happened first was my email blew up, like many of ours did, I'm sure. And then social media started going wild. So what happened today was the Supreme Court announced its opinion and released its opinion in New York State Rifle and Pistol Association v. Bruen. That's a case that was a direct challenge to New York State's concealed carry law. New York State has a carry law like many other states do, but it also has a discretionary element written into that law, an element that allows for local licensing officials to decide whether or not people really need a permit in order to carry firearms concealed in the state. And as you could probably imagine, New York routinely denied people's applications. And so this case challenged New York's carry law. And in so doing, though, kind of challenged a lot more about Second Amendment cases that we've seen in the past 10 years, since 2008, actually, so the past 14. So what's really monumental about New York State Rifle and Pistol Association is it in effect does three things. One, it's the first time that the Supreme Court has explicitly recognized the right to possess or to bear an arm outside of the home. Two, it strikes down New York's discretionary, what we call may issue permitting systems, meaning the state may decide to issue a permit if it thinks that you met the proper requirements. New York is one of 6 states, I believe, in the District of Columbia that have those laws in place. So those other states will be scrambling. And the third thing it does, and what makes it so monumental, really, is that Justice Thomas, who authored the opinion, goes through an in-depth analysis of how courts are supposed to evaluate Second Amendment challenges. And while it doesn't do anything necessarily groundbreaking, it really just reiterates the test that was established in 2008 in Heller and then reiterated itself in 2010 in McDonald v. Chicago. This opinion thoroughly lays out how courts are to analyze Second Amendment challenges and rejects a test that has been used by federal courts across the United States in order to allow for infringements upon people's right to keep and bear arms. So there's a lot here. I'm sure we'll dig into a lot of that. I know that was a long introduction, but those are kind of the 3 big takeaways and what made this such a monumental opinion in such a busy morning.
Well, I noticed the opinion is 6-3. With Chief Justice Roberts in the majority. There have been occasions in the past where the Chief Justice has been the odd man out and joined the dissent in some cases that have been hot button. Here, he didn't do that. He is fully in the majority. What's your reaction to this being a 6-3 decision as opposed to 5-4?
Yeah, so it is very interesting. And for people who watch the court, right, there was a lot of expectations about whether or not Roberts would swing, as you're saying. I think what's really interesting here is that for those that are familiar with court procedure, there's a specific way that the court decides who writes the opinion. some of these are practical considerations, some of it's who's written more, who's written less, but the way the opinion is ultimately assigned out is either the most senior member in the majority gets to decide who writes the opinion, or the Chief Justice, if in the majority, always gets to decide who writes the opinion. So a lot of people thought Roberts would join the majority in order to assign the opinion to somebody that would write potentially a weaker opinion, something that didn't, as forcefully reiterate Heller, or didn't as forcefully strike down New York's law, but instead, not only did Chief Justice Roberts join the majority, he also assigned this opinion to Justice Thomas, who has been, a loud voice in arguing that the court needs to take up a Second Amendment case. And this is one of the first Second Amendment cases the Supreme Court has heard on the merits since 2010. And Thomas has objected from that practice regularly and has regularly filed dissents in other cases where the court refused to hear the case and said that those cases violate people's Second Amendment protected rights. So I think there's a lot of criticism of Roberts out there, rightfully or wrongfully so. But I think in this case, you have to give him a little bit of a kudos for not only joining the majority, not only vindicating the Constitution and people's Second Amendment protected rights, but allowing Thomas to kind of take the reins and really draft a very strong opinion in favor of the people.
Yeah, I completely agree. A lot of commentators have said, formally it's the Roberts court, but really it's the Thomas court because he's the most senior justice besides Chief Justice Roberts. So it definitely bears his mark. I guess I want to ask you more about this opinion, in terms of what the lower courts did wrong and what other courts have been doing wrong. We've seen a lot of opinions at the appellate level and district court level where gun control restriction is upheld, even though those courts acknowledge Heller and acknowledge McDonald. So I think you've probably read more of the opinion than me. I've tried to get through all 135 pages of it this morning. What did those courts do wrong, according to Justice Thomas?
Yeah, so these lower courts have been applied, and this includes district courts across the nation, which are kind of the first federal court level that you would be exposed to. So, for us, for those in the state of Colorado, it's the District of Colorado. And then this includes also the circuit courts, which are the intermediate appellate courts where, if you lose at the district court or you win at the district court, you can go up to the Court of Appeals and they'll review the case. Well, almost all of these lower courts, with the exception of a single circuit, have been applying a two-step test, a two-step inquiry, a two-part test, whatever you want to call it. It involves two steps. The first is to determine, they look at the law and they determine whether the law affects conduct that infringes upon the core of the Second Amendment's protections. Now, this analysis is where a lot of courts have couched their workarounds to enforcing the Second Amendment's protections, because they would say that certain things were not core, or certain things fell outside of Heller's recitation of core, or they would limit Heller to saying that Heller only really protects the ability of people to possess functional handguns in the home for self-defense, which is much more narrow than what Heller is. But that's step one. Step two was then to determine the appropriate means and scrutiny and to apply. And so basically that's a legal term for balancing the protected right versus the state's interest. And if something was a core protection of the Second Amendment, then the court would apply strict scrutiny, meaning that the state had to have a very, very, very strong showing that their law was necessary to further their government needed ends, and that there wasn't a less restrictive means of doing so. If the law fell outside of the core of Second Amendment, so it was still a violation or was still protected by the Second Amendment, but wasn't in that kind of most central portion of it, then the law would be subjected to intermediate scrutiny, which is a much lower burden for a state to meet. And in fact, what circuits were really doing is in imposing this intermediate scrutiny, they were really just deferring to legislatures. And deferring to states saying, look, the state says that they need this, so they need it, and that's all that really matters. And Thomas goes very strong at that argument. He does a lot of work to say that's not sufficient. That's not the way that we evaluate constitutionally protected rights. And even goes as far as saying that both Heller and McDonald specified that this is not a right that should be subjected to the interest balancing of courts, and that it was already subjected to the interest balancing of the people when it was drafted and ratified in 1791. So, or when its protection was ratified in 1791. So that two-step test is what's really been applied in courts across the nation. And that two-step test has been firmly rejected by the Supreme Court. In fact, at one point, Thomas says that one of the problems with the two-step test is that it's one step too many. And that really this should be a one-step analysis. And that is focused on the original meaning of the Second Amendment as informed by history. I'm not sure that I can hear well. So why don't I dive a little bit into what that means and this idea of the Second Amendment informed by history. So this is something that Mountain States Legal Foundation has been arguing for years. It's something that Second Amendment scholars, Second Amendment lawyers have been arguing for years as well. And it's very simple. And essentially it says that we should interpret the Constitution to mean what it meant when it was ratified. And so it's very straightforward. It's not this crazy new position that some people like to say that originalism is. So in the Second Amendment context, what the court is to do is what the court did in Heller, what the court did in McDonald, and now what the court has done in Bruen. And that is they analyze the text of the Second Amendment to see what the text actually means. And in this context, one of those considerations was to bear arms. And so when looking to bear arms, the court looked at the text and said, we understand that to mean people carrying arms outside their home. And thus, to keep and bear arms protects not only the possession of firearms in the home, but also protects the carriage of those firearms in public in some manner. The court also, though, doesn't just look to the pure text, but also informs that textual analysis with a historical analysis. And what that is to do is to see what did these terms actually mean when they were written, when they were debated, and when they were ratified. Some terms, some words change their meaning over our history and as language evolves. But what's important is that those protections, the core of those protections, stays the same and stays true to our constitutional form of government. And so here the court goes through an in-depth analysis and looks at 15th century, 16th century, 17th century, all the way through 19th and 20th century law to start engaging in this historical analysis to determine what did these protections mean? What did it mean to bear arms? And some of those the court rejects and says, look, some of these 15th century considerations are just too far removed and don't have a clear lineage to our founding, so they don't inform our analysis. The court also says that some of these 20th century and late 19th century considerations or laws or factors are too far removed from the founding and from the framing, and that they don't necessarily bear on an appropriate analysis of that. So it really does focus in the historical analysis, which is something that people have been concerned about with originalism. So that was another plus of the opinion. But it really is this grounded analysis in the text of the Constitution and the founders and framers and the public's understanding of what those terms meant, what the Constitution said, what the Bill of Rights said, and what it protected. I think our esteemed general counsel is still on mute, so we'll go ahead and keep talking about the opinion generally. Also, if you have
Sorry, Cody.
Oh.
My machine enforced, I think, Santa to manually unmute me. What do you make of the concurrences here? Given that we had a couple of concurrences from Justice Kavanaugh and Justice Alito and Justice Barrett, all members of the majority, which seemed to add color to the opinion, in some ways maybe even stress that it was a more narrow opinion than we ought to think it was. If you've had a chance to react to those, what's your reaction to those concurrences?
Yes, absolutely. And I should say, obviously, we're going to be digging through this opinion for days and weeks. So I'm sure more will come out, more nuance will come out, and we'll understand a lot more of the contours of it. But one important takeaway of those concurrences is that each of the concurring justices make sure at the very beginning of those concurrences to state that they fully agree with the opinion of the court as drafted by Thomas. So this isn't a plurality opinion, meaning that the justices all agree with the outcome, but not the reasoning. It's clear that all of the justices in the majority, the 6 that are in the majority, agreed with the outcome and the reasoning, and that this opinion is authoritative for years and decades to come. It will be part of that standard canned response as judges sit in their confirmation hearings and say that it is a settled law or settled decision of the Supreme Court and entitled to the stare decisis effects thereof. But each of the concurrences addresses something differently. So Alito goes and takes on the dissent. So there's one single dissent with all 3 of the minority members of the court joining in that dissent. So Alito really focuses on attacking the dissent or dealing with its arguments. Kavanaugh and the Chief Justice are focused on the precision of the opinion. They are focused on the fact that the opinion strikes down New York's discretionary element of its concealed carry law. So the Supreme Court's opinion does not strike down states' abilities to grant permits for the purposes of concealed carry. It does not strike down states' ability to do background checks, to do those sorts of things that are already in place in the states that we call shall issue jurisdictions. And those are the states that the licensing official shall issue a license so long as you're not a prohibited person or otherwise prohibited by state law from possessing or carrying a firearm. Those are much more defined legal requirements that are set out in the statute as opposed to the discretionary requirement. So this case does not affect those defined legal categories, just the discretionary element. And one thing, though, is that Thomas does address this in the majority opinion. He does say in a footnote that this doesn't affect shall issue jurisdictions, but Kavanaugh and the Chief go more in depth to address that. And that's where it is more narrow in the sense that it's not saying states can't license people, even though the vast majority of the states in the United States, or not the vast majority, but the majority of the states in the union now allow for free carry and don't have permitted requirements or don't have these issues. But this opinion doesn't stop states from having permits. It just stops them from having discretionary permits. And so that's where that Kavanaugh concurrence comes in. The Barrett concurrence focuses on a very niche issue of constitutional interpretation that did come up at oral argument. And it was the question of whether the court determines original public meaning. So when we're talking about that text and history analysis, does it ground that when the amendment was ratified? So in this case, 1791, or does it ground it when the 14th Amendment was ratified? Because the 14th Amendment is where we get incorporation and where we get this doctrine that the protections in the Bill of Rights also apply against the states and not just against the federal government. And so that analysis would be grounded in 1868 instead of 1791. And so Barrett kind of goes in her concurrence in some detail to address that.
So I thought that this emphasis on text, history, and tradition was interesting. Of course, the Senator Keeping Bear Arms filed an amicus brief in the case, emphasizing some of those themes. What's your reaction to the opinion in terms of what we as an organization have emphasized in our brief vis-a-vis the majority opinion and some of the concurrences?
Yeah, so 2 things there. The first would be we have been advocating for this actual application of Heller for years. And you can look back in our briefs. I mean, the center was founded in 2020, but Mountain States has been doing Second Amendment work for longer than that. And so you can look back to our briefs that we filed with the Supreme Court and with other courts, and you can see that we have consistently argued for that Heller text, history, and tradition test. The court has even better stated it now as a text as informed by history, which is good because that question of tradition is what drew in this question of how far into our history do you go? Do you go into the 18th, 19th, 20th, 21st centuries? So you can see that we have been advocating for this test for a long time because it simply is just the appropriate application of Heller. We weren't trying to create some new standard or have the Supreme Court adopt some new means of interpretation. We just wanted the Supreme Court to enforce the standard that it had set forth. The other thing is, in our brief, in this case specifically, we addressed surety laws. These were a particularly contentious issue because there was a set of laws in the early 1800s that were really started by Massachusetts. And the laws basically said that if somebody had gone armed to the terror of the public, they could be brought before a justice of the peace, and they could be required to post a bond in order to continue to carry, in order to have this protection if there was some level of disturbance of the peace. Now, gun control advocates, and New York in this case, argued that that meant that states broadly had the authority to regulate public carry, and that public carry wasn't a normal practice, even by the early 1800s. And when we looked at history, when we looked at these statutes, and when we looked at their sparse application in the historical record, it was very clear that not only did these statutes confirm that there was a broad practice of carrying in public, but that the only possible restriction on that states were enacting was to react if people carried into the terror of the public, is kind of the quote, is the language. And that didn't mean just carrying, that meant literally doing something that was terrorizing. And so if somebody were, walking around with a firearm in their hand, pointing it at people down the street, then that obviously could be prohibited and regulated. But the mere act of carrying a gun wasn't terror inducing. So we dug into those surety laws. The majority opinion does a lot of work tangling with those laws as well, comes to the exact same conclusion that we did, cites a lot of the same statutes that we provided in our brief, and pulls a lot of the same analysis that we had made in our brief as well. So it's very clear that that argument informed the court's analysis in this case.
Now, I want to talk about the concurrence by Justice Alito as it relates to the dissent. So Justice Alito's concurrence about how this is actually a very obvious extension of the home. So you're allowed to have a gun at home under Heller. All we're doing is saying now you can go outside, right, with your gun. That's not that big of a leap from what we've already said before. Justice Breyer, in his dissent, starts to cite a lot of figures about public shootings and the safety interest of governments. And Alito pushes back and says, do you really think that those laws would stop a shooting like the Buffalo grocery store shooting, which, happened in New York? And I thought that interaction between the dissent and the concurrence was interesting. If you've had time to review the dissent, what do you make of it? And then how did you view that interaction? Do you agree with me, or do you see any other elements to it?
Only very briefly. So I'll couch my statements with, obviously, we're going to keep reading this and reviewing this and digging into it. Kind of two things to that point. The first is that this isn't some earth-shattering reading of the Second Amendment, right? It's in it's only 27 words. It's in the text. It says keep and bear arms. When you look at the definition of bear, no rational, reasonable person can assume that that means anything other than carrying arms outside the home. Thomas does this a little bit even in the majority, and I think Alito touches on this as well, of the fact of bear didn't protect somebody's ability to have a rifle slung over their shoulder in their bedroom. I mean, that you can keep arms in the home and you can possess arms in the home, assuredly, but bear very obviously protects the right outside of the home. So this tangling that people were doing, trying to couch the right to just a mere presence in the home or protection in the home violates the clear text of the amendment. The purpose of the amendment, too, which the court delves into, is that you have the right to protect yourself in a case of confrontation. You have the right to protect your life. You have the right to protect your loved ones. And that also extends to your community, which was so important during our founding and era. I mean, the ability of peaceable citizens to protect themselves, their loved ones, their communities was what our country was founded on and what we won a war over. And it's just very clear that that doesn't just apply in the home, and that is not just limited to your ability to preserve your life when you're sitting in your living room, right? You have an ability to preserve your life no matter where you are. And so it is just this, there is a lot of gymnastics going on around these concepts. As to the public shooting side, Mountain States has talked about this. We've released statements. What is clear, we understand that allowing people, peaceable Americans, to protect themselves in public is the best deterrent for public shootings. Gun-free zones are immoral, and they stop people from being able to preserve their life. And we have recognized this repeatedly. This isn't a secret. We know that shooters target gun-free zones. And so, yes, while the dissent kind of brings out some of this data on violent crime and brings out this data on public shootings, the key here is allowing people to be able to protect themselves, to getting these legislatures out of the way, to getting these laws out of the way that disarm people. And whether that's in, predominantly Republican-controlled states and rural areas, or if this is in predominantly democratically controlled states in urban areas, people have a right to protect their lives. And that should remain true no matter where somebody lives, whether it be Manhattan, where this law is going to be affected, whether it be downtown LA, where this is also going to have an effect, or whether it be in one of the states that recognizes that and gets out of the way already.
Well, so I understand that it's been only a few hours since the dissent was issued this morning, but what do you make about the fear that this prevents cities from being able to stop people from carrying in sensitive places? Like, are we going to have subway shootings in Manhattan now? Are we going to have shootouts in churches and playgrounds in the city? Obviously, our position in Mountain States has been that you don't want to disarm people, but the dissent says, well, okay, but now you're going to have guns everywhere you go. What do you make of that criticism?
I think it's generally unfounded. First, criminals don't follow laws. New York has plenty of people that are being prosecuted for carrying firearms in the city, even though New York just generally doesn't issue permits for people to carry firearms in the city. This was something that New York tangled with at oral argument, where they addressed the fact that if they think that there aren't guns currently on the subway, then they're living in a different universe than the rest of us. And their crime data shows that there are guns currently on the subways in New York. All that this law does is prevent people who don't want to run afoul of the law from carrying. It just prevents peaceable Americans. It prevents people who want to be law-abiding from carrying firearms. It doesn't stop the people that are going to go to subways and enact acts of violence against defenseless individuals. And that's something that they just refuse to tangle with, and that is a huge problem. Moreover, this doesn't stop in no way a state's ability to regulate concealed carry permits. The court, the opinion of the court by Thomas, the concurrence by Kavanaugh and the chief, they all address the fact that states can still have a licensing system that has objective criteria, such as whether a person's a prohibited person or whether they're a certain age. So those are still standing. The last is sensitive places. There will definitely be litigation coming out around sensitive places. That is going to be a big takeaway from this opinion. I've already seen at least one city say that they're going to try and deem any metropolitan area or any area with more than 10,000 people as a sensitive place. So you're going to see a lot of tangling around this question. Luckily, the opinion of the court heads that off. It says that New York can't deem Manhattan as a sensitive place just because there are a lot of people there and just because there are law enforcement that patrol the area. That doesn't create a sensitive place. What cities and states would have to ground sensitive places in is, like everything else, a historical tradition. And there's some authoritative writing on this. People that we've worked with regularly, David Kopel and Joseph Greenlee, authored an article about sensitive places that was cited in the Supreme Court opinion that is going to be, I imagine, very well read over the next few weeks, even though it already is very well read. But that sensitive places doctrine is absolutely going to be a point of contention moving forward.
All right, we're about at time. I mentioned that we're going to 20 to 30 minutes, but before I close, let me get your wild speculation about where we go from here. Mountain States is involved in a number of cases involving 18 to 21-year-olds having arms, about felons maybe having a right to possess arms after a record of clean history, about magazine limits, about hobby kit guns or unserialized firearms, which some people call ghost guns. What does this decision mean for cases like those?
The biggest impact that Bruen will have on cases like those is that third takeaway that I gave at the beginning, and that's that Bruen reestablishes the Heller test, reestablishes this test of looking to the text as informed by history. So, for example, there are a couple cases that are pending before the Supreme Court that they haven't granted cert yet, and they haven't agreed to hear. We'll probably see all of those cases get sent right back down to district courts with an order that those district courts follow the tenor of Bruen. But for example, there's a case there called ANJRPC v. Gruel, and that's a challenge to New York's magazine ban. New Jersey's magazine ban. New Jersey currently bans magazines that possess more than 10 rounds. In that brief, we went through an extensive historical analysis to show that firearms capable of firing more than 10 rounds were well known at the founding era. Magazines and their prototypes, their historical antecedents, if you will, were well known during the founding era, during our ratification. And despite the fact that those were all well known, the people advocating for these laws and gun control advocates can't point to a single law that prohibited the possession of these firearms that could fire more than 10 rounds, or these proto magazines, if you will. So it's clear that in these contexts, we're going to see the historical analysis demonstrate that a lot of these laws that have been litigated over in the past 14 years since Heller are going to be relitigated, and with lower courts hopefully this time following the Heller analysis and looking to the historical significance and the historical events surrounding the Second Amendment, we'll see that things like 18-year-olds were well within their right to possess arms. In fact, I think the average age of the revolutionary force that defeated Britain was 18 to 20 years old. So you're going to see these things come out. You're going to see that firearms capable of firing more than 10 rounds were well understood. You're going to see that firearms like the AR that were useful to civilians, but also may have been used in military applications, were protected and were understood to be protected and were necessary for civilian ownership. So that is going to be the big takeaway, is that as this test is applied out in the different courts, how that history analysis is going to inform the analysis of all of these different gun control laws across the United States.
All right, well, thank you for that analysis. So I think we'll leave it there. Thank you to everyone for joining our Courthouse Steps webinar today. The Center to Keep and Bear Arms is very excited about this opinion and the future of what it means for the Second Amendment rights in our country. Stay tuned, stay posted to our email address list for future webinars. We'll definitely be doing a few more of these over the next week and a half as the Supreme Court rounds out its term. With that, we are adjourned. Thank you, everyone.
Thank you.